Swayam Prabha. Digital India. Educated India.
Dear students, today we will study about a different theory of jurisprudence, which is an extension of the last lecture on analytical or positivist school of law. This is a branch of positivist school of law, and this branch is called pure theory of jurisprudence. What is this pure theory of law? Who was the propounder of this theory? That we will see in this lecture. So, in this lecture we will try to understand about the main proponent of this school, who is Professor Hans Kelsen, and then in this lecture we will also see that what were his main thoughts, and in that way we will understand the legal meaning of the word act, and thereafter types of act, and thereafter meaning of the word norm. Then we will see that how the norms can be created, thereafter the validity and effectiveness of norm, and then we will see that how Hans Kelsen talked about the positive and negative regulations, and thereafter we will talk about the basic norm of a legal order. Finally, we will see about the hierarchy of norms, and also that how many different types of dependent and independent legal norms are there. So, be prepared for understanding all these main thoughts of Professor Hans Kelsen. First of all, we will see about his own personality, Hans Kelsen's personality. Who was he? Whether he was only a person who taught in the university, or he also discussed, debated new emerging issues of jurisprudence. Students, Professor Hans Kelsen was born in 1881 in a Jewish family, and thereafter his family, when he was not even he has attained 5 years, his family moved to the Austrian capital of the famous city of Vienna. And thereafter in the 20th century, early 20th century, in 1906, he was awarded with the highest degree, that is PhD in law. Thereafter he joined University of Vienna. So, you can see that how early he was interested in the studies, then further pursuing his studies, and finally he joined the University of Vienna. Not only that, when the World War first began, he also was giving advice as a formal legal advisor to the war minister of Austria. As you all know that Austria was also involved in the First World War. Before that, Austria was under the Austro-Hungarian Empire, and when the Austro-Hungarian Empire was involved in the First World War, he was the legal advisor to the Minister of War. Finally, he also was instrumental in drafting the Constitution of Austria, which is a great thing. When the new constitution was made, he was the person who was there instrumental to make this constitution. And then, because there was a change of events, and so after World War I, he thought that now his job in Austria was over, and he moved to Germany, because in Germany he was interested to learn more and more, and because in Germany there were so many scholars. So, he moved to Germany with the whole objective to pursue his interest in further studies. But when Hitler came to power in Germany, he thought that now this is not the time to stay in Germany, and what he did, that he then moved to Geneva. When he moved to Geneva, that was also the place where he tried to pursue his studies, but then he thought that better place would be US, and in 1940 he moved to the US, and there he remained for the next more than 30 years, and that was the place where he did lot of work, and his works were published also. Let us see that what were his works. As you all know that Hans Kelsen was a great proponent of pure theory of law. What was this all purity about? Now he talked about the fact that when Austin said that because of fear of the king, persons obey the law. Now he was saying that you see that the psychology is involved. It is not that there is law, therefore the person is bound to obey the law. It is because of psychology, the fear that is instilled in the person, therefore there is such kind of obedience to law. But Kelsen disagreed. He said no, this is not, this is impure thought in the discussion of law. He said that the law should be discussed in a pure manner. Law should not be discussed with incorporation of the psychology in law. And then he said, let us not discuss that, okay, what is the meaning of the political meaning of sovereignty, the political superiority, the political inferiority. We should talk about in terms of law, and therefore his whole theory is called the pure theory of law, and therefore we have to understand that what is this purity. He tried to build his theory on the basis of purity, means the legal things only, the rules, the norms, what are the kinds of rules, how rule is made. Before that he said that let us try to understand the word act, because from this word he will move on to the next word, which will be the norm, and thereafter we will see that how norm is created. So all these things are bound, tied with each other, and therefore first of all we will see that how the first thread which he started to weave, and that first thread was the word act. Let us try to understand the word act and what is the legal meaning of that word act. So what he said, that normally the word act is conveying the message that someone has done something, no? This is the act. But in the eyes of Professor Hans Kelsen, what he said, that the word act has two meanings, and these two elements, these are distinguishable in a body of facts. So what are those two things? How those two things are distinguishable? He said that act, the first element is an act itself. What is that? What does it mean? It means happening which occur at a certain time and in certain place, perceived by our senses, and which is an external manifestation of human conduct. So that how this some action has been done, and how that action has been perceived, how that has an external manifestation, that means the act itself, the happening. So some happening is seen by someone, that is an act. And then he says that the legal meaning, what is the legal meaning of this act? So these are the two things which are distinguishable. The first is act itself, and then he says, take an example, that suppose people assemble in a large room, then they make speeches, some raise their hands, others do not. What is this? What is this happening called? This happening is called the external happening. This is the act itself. And then what is the legal meaning? Because this is the act which can be done at some place, but what is the legal meaning of this act? Now what he says, that it seems as if the legal meaning is that a statute is being passed and some law is being created. Now, this is the legal meaning. So, someone will say that okay, suppose if there is a room in which that large room, some people will raise their hands and then make speeches, and then they will say that okay, this should be done or this law should not be there, but that is an act itself. But what is the legal meaning? That some law is being created, some statute is being passed. So, students, you might have seen in this slide that the word act has two meanings. Normally, we do not understand about the meaning of the word act in this way. He gave a new meaning, he gave a new interpretation to this word act, and therefore, I hope that you might have understood what he wanted to mean by the word act. Further, in this slide you will find that he said that there are two types of act. One is called subjective act and other is called objective act. Subjective act means that someone makes some dispositions, and he states or she states in writing what is to happen when his belongings, and when he dies, what will happen to his belongings. So, this is kind of act, but what is the subjective meaning of an act, of this act? The subjective meaning of this act is testament. You might have heard the word will. So, this is the meaning of will. It means, suppose if this happens, someone makes some dispositions and someone states in writing, okay, this will happen when I will die. What does it mean? What is the meaning of this act? The meaning of this act is again in subjective meaning. What is the subjective meaning of this act? The subjective meaning is that this act is the act of testament writing. This act is the act of will writing. And what is the objective meaning of this act? Subjective is, you have understood, but what is the objective meaning of this act? Now, because in this act you might have seen that there was no evidence of seeing that how this disposition was made, there was no evidence that who saw this, and therefore, maybe that the legal formalities of making dispositions, legal formalities in making of the wills, that were not completed, and therefore, this is the objective meaning of the act. So, objective meaning is, according to Professor Hans Kelsen, the objective meaning is how a thing, how an act is to be understood in the legal way. So, that is about the objective meaning of the act. Normally, we say that objective means, you know, what is the object or what is the factual thing, but then according to Professor Hans Kelsen, this was a different thing, and what he said that the objective meaning is different. So, I hope that in this slide you might have understood that what are the different kinds of act which are known by Professor Hans Kelsen. Once you understand these words, the act, the different types of act, then now is the time that you will understand the meaning of the word norm. Now, norm is also commonly used. This word is commonly used, okay, this is the norm of the society, this is not the norm of the society. But then Professor Hans Kelsen gave a new meaning to the word norm. And how does he say so? You can see in this slide that what he says, that physical existence of something can be determined by the laws of causality. Causality means cause and effect. And then what he says, that in the last slide you also have seen that the objective meaning of the act results from the interpretation of the cause and effect. So, in the last slide we have seen that, you know, someone in the large room does something, that is a cause, and effect is that maybe there will be a legal meaning to it. So, this is how you see that what he said, that the specific legal meaning of an act is derived from where? How have we seen that This is the meaning, this is the objective meaning. So, what he says, now he comes to the point, what he says, that specific legal meaning of an act is derived from a norm. Now, here comes norm. Norm is what? Norm gives the objective meaning to an act. So, what is this norm? Norm confers legal meaning to the act, so that it may be interpreted according to the norm. What can be interpreted? The objective act has to be interpreted according to the law. Now, then once you have understood the word norm, what he says, that these norms are the objects of jurisprudence. These norms are the objects of the science of law. So, jurisprudence, according to pure theory, it is not that you have to go to political science, you have to go to sociology, you have to go to psychology. What you have to do? You have to purely base your thoughts on the legal norms. What are the norms? How the norms are created? And now what he says, that these norms, what you have understood now, these norms are the subjects of jurisprudence. By norm, what did he mean? By norm, he said that something ought to be or ought to happen. So, what can be the conduct of a human being when a particular situation arises, and how the human being would conduct his behavior or her behavior in a particular way. That is the meaning of the word norm. Norm means that something ought to be, something ought to happen. This is the meaning of the word norm. So, norm might have understood that is not the meaning according to Professor Hans Kelsen. What he says is that what ought to happen, what ought to be, this is the meaning of the word norm. It means that the norm is those certain acts which are directed towards the behavior of others, how others ought to behave, how others will do something. And therefore, what he says, ought word is the subjective meaning of every act that we have understood, every act of will. So, this is how you see that it is little bit technical, but I hope that you might have understood that how he came to that point where he was trying to make us understand what is the meaning of the word norm, because ultimately every basic tenets of this pure theory of jurisprudence, that is based upon the word norm itself. So, once you understand the meaning of the word norm, then you will understand how does he further develops his theory. Now, in this slide, we will try to understand that how a norm is created. We have seen that what is the meaning of the norm, and we have also seen that act and what are the types of act. Now, we will see the norm which Hans Kelsen was talking about, how that norm is created. Now, in this slide you will see that norms can be created by three ways. How? By commanding the behavior of others. Someone is there who commands the behavior of others, that is one way of creation of norm. Or not someone, maybe suppose, maybe example that there may be not only one person, but a group of persons by a competent authority which have the power to command the behavior of others. So, that is one possibility by which norms can be created. The other way is by permitting some behavior. You permit that someone who is enjoying or having this office may do this thing. This is that you give privilege, this is that you give permission to some category of people that you are permitted to do this. like you permit your armed forces to go to the warfield and protect the territory of your nation. And finally, norm can be also created when you authorize some behavior. So, this authorize, giving authority to some person, to some group of persons, like you give authority to the judiciary that okay, you do this, you adjudicate the problems. So, by authorizing some behavior, you also can create norm. In other words, norm is the meaning of an act by which three things can be done. Certain behavior is commanded, certain behavior is permitted, and certain behavior is authorized. So, these are the three ways broadly in which Hans Kelsen said that a norm can be created. Finally, he said that norm can also be created by way of custom. Now, this is again a development, because you might remember that Professor John Austin, he had said that there is no place of custom, because I told you in the last lectures that Professor John Austin, he was a person of the British era times, when the Britishers were ruling all over the world, or most of the parts of the world. Now, in that case, what he was trying to say, he was just focusing upon the legislation, he was focusing upon the power of the sovereign. But now this is the development after First World War. You might know that great empires, those were broken down, and this was also the case of Austro-Hungarian Empire. You might have also known that the British Empire was also weakened after the First World War, and therefore, when this is the thing that no customs have also to be coming into the norms, that was a great development which Professor Hans Kelsen accepted, and he said that customs are also in the norms. So, finally he said norms can be created by customs also. So, in this way, maybe that the people in India, people in Bharat, they could say that whatever our customs are, that should also be incorporated into the laws of our country. So, this was a great development. Next, we will move on to the validity and effectiveness of norm. Sometimes you wonder that whether any norm can be created by the authority in question, or should the norm be tested? Who can test it? Now, this is a development. You remember what John Austin said? John Austin said there is no need to validate the norm, there is no need to validate the command of the king. But Professor Hans Kelsen says that even the norm can be tested for its validity and effectiveness. How that can be done? That we have to see, that validity, how the validity of the norm can be tested. He says validity of a norm is an ought norm and not an is norm. So, is and ought. What is different, and what ought is a different thing. So, how you will see that validity? He says that validity you have to test on an ought platform, not on is platform. And what he says that effectiveness, when we say effectiveness of norm, effectiveness is an is fact, means that the fact that the norm is actually applied and the fact that people actually behave according to the norm. So, this is the factual thing. This is what is the factual thing is the is fact. So, effectiveness is dependent upon is fact, that whether the norm is actually applied and whether people actually behave according to the norm. And then he says that a general legal norm is regarded as valid only if the human behavior that is regulated by it actually conforms with it, at least to some degree. Now, you do not say that every action of the person must fully conform, even if to some degree if it is conformed, it means that the behavior is and the norm is valid. And then he says that a norm is not effective at least to some degree, maybe that there will be some norm which will not be effective even to some degree, then what will be the case? Then he says it is not regarded as a valid legal norm. So, norm must be at least observed by many people at least to some degree, and but suppose if there is no such kind of acceptance, if it is not effective even to some degree, then he says that this is not a valid legal norm. So, a minimum of effectiveness is the condition of validity of norm. So, this is very important, how you will have to understand that what is the effectiveness. It is just minimum of acceptance, minimum of effectiveness is the condition of validity. So, in this slide what we have seen that norms, how the norms are valid, how the norms are effective, and how Professor Hans Kelsen tried to make us understand these different types of norms. Further, what he said that regulations are also to be seen. Regulation is also a norm. We discussed in the last slide that regulation can be commanded, and what about the different types of regulations? Now, there are two types of regulations, one is the positive regulations and other is negative regulations. The behavior which is regulated by a normative order may be a definite action or the omission of such an action. So, that is how what he says that positive regulation commands a definite action of a definite individual. So, definite action, when there will be a command for the definite action or not only action but omission of a definite individual, then that is called positive regulation. So, in a particular way someone has to do something. So, that is called positive regulation, and this includes such a situation when an individual is authorized by the normative order to bring about certain consequences determined by the order. So, this is about authorizing. You authorize when an individual is authorized to bring about certain consequences. So, police, you can take the example of police, that how police is authorized to do some act of law and order, how to protect the law and order of the particular place. So, authorize in doing that, police can arrest the persons also. So, that you can see in the new BNSS and BNS. So, what I was telling you, the last positive regulation type is permitting. Permitting, when the norm permits an individual to perform an act which is otherwise forbidden, such as self defense. So, permission is given. You might know that in the earlier CRPC and the new BNSS, these types of protecting one's body, that is called self defense, that is allowed, and you can use force also in self defense. Negative regulation is the another type of regulation. Negative regulation means that human behavior is not forbidden by the normative order. So, when there is nothing which is specified that in this way the action can be there, in that way there will be the action. So, if that is not given in any kind of norm, then that is called negative regulation. So, in this slide we have seen that regulations are of two types, positive regulation and negative regulation. Now, once you understand these different things about related to the norm, what we have to see, is there any basic norm in a legal order? What is, if that is a possibility, what does that mean? Now, he says, Professor Hans Kelsen says that the reason of validity of any norm is derived from Grundnorm. An interesting word, you might have heard about this word maybe when you had started studying law, or otherwise maybe that you might not have heard this word. So, Grundnorm, what is this Grund? Grund is a German term and Grundnorm means the basic norm. What he says, that the region of validity of norm is the basic norm. What is that basic norm? Basic norm is that norm beyond which one cannot look for a more ultimate norm. So, that is the basic norm. You do not have to look further. Like what you say, that suppose if you want to test the validity of a particular norm, you finally, that is the final stage, that you move to the basic norm of that legal structure. Once you go there, there is no further point to go. That is the last point, that is the border point. And what he says, that basic norm provides the foundation for a system of dynamic character. So, basic norm is giving you direction that whether the system is a dynamic system or not, and therefore, law is what? Law is a dynamic system of norms. Dynamism is there because norms can be created, because norms can be permitted, norms can be authorized, and therefore, this is a dynamic system. And when this dynamism is there, that is, when you remember last lecture, that when Hart was saying that how a particular system is a developed system when there is a secondary rule of obligation. This is how Professor Hans Kelsen says that the system of norms should be dynamic in nature. And he says that the norms of a dynamic system have to be created through different acts of will by those individuals who are authorized to create norms by some higher norm, and this authorization is delegation. And further he says that the basic norm of a dynamic system is the fundamental rule according to which norms of the system are to be created. So, this is the importance of the basic norm of the legal order. Once you understand the basic norm, then you have understood that whenever you have any doubt regarding the validity of a norm, you can go to that point and finally you can see that whether this norm is enjoying the validity. And this is how even the courts do. When a particular norm is challenged, when a particular statute which is passed by the legislature is challenged, where is the final authority? How do the highest court of our country validate the law? They validate when they test the validity with the Grundnorm. And what is the Grundnorm in our country? The Grundnorm may be the highest law, that is the Constitution. So, in this way, what Professor Kelsen said, that there exists a hierarchy of norms. There is no psychology, there is no what we say philosophy, there is no political science, there is no sociology, but in his pure theory of law scheme, what is there? He says that there is a hierarchy of norms itself. There are superior norms, there are inferior norms. The superior norms are those norms which determine the creation of another norm. Inferior norms are those norms which are created according to superior norm. And therefore, what Professor Kelsen says, that legal order is not a system of norms coordinated to each other, standing side by side on the same level. It is about talking about the hierarchy of norms, going above and finally reaching the basic norm. And therefore, what finally he says, that legal order is rather a hierarchy of different levels of norms. Now, he is talking about the whole legal order. There is a legal order, it is very vast. The legal order is not having only one kind of rule, it is having different thousands of rules and different regulations. So, how these are intertwined with each other? These are intertwined by way of this hierarchy, this superiority of norms, the inferior norms, etc. And this is about the legal order. Jurisprudence is not about going to different streams of learning, but jurisprudence according to Hans Kelsen is the purity of law, the purity of jurisprudence, the purity of the law where you will only have to go to the norms, the creation of norms, validity of norms, effectiveness of norms, hierarchy of norms, and then moving to the Grundnorm. Finally, he says about the different types of legal norms. One is called dependent norms and other is called independent legal norms. Now, what are those dependent norms? Dependent norms are facilitative norms. They facilitate rather than coerce people, like right to make a will, powers of the president of the country, powers of the judges. These are facilitative norms and therefore, these are called dependent norms. Dependent norms are attached to the independent norms, which are coercive norms. Independent norms are coercive norms which stipulate some sanction for contrary behavior. Dependent norms are dependent for their validity on the independent norms. So, validity of dependent norms are checked on the basis of independent norms, or maybe otherwise vice versa, that dependent norms derive their validity from independent norms. Like section 299, now it has been changed, but the earlier section 299 of IPC was a dependent norm because it derived its validity from section 302 of the IPC. As I told you that independent norms are coercive norms and independent norms stipulate sanction as reaction against non-observance. So, you see that norms now in the eyes of looking from the angle of the sanction, we have to differentiate the regulations into two types. One is independent and other is dependent. Independent legal norms have sanctions inbuilt and the dependent legal norm may not have sanctions. They are rather they are facilitative norms and which facilitate the doing of something, like a diplomat who has the powers to do something, to negotiate a treaty on behalf of the country. With this we will now evaluate that how much strength was there in the theory of Professor Hans Kelsen. Kelsen's logic and precision was scientific. He very precisely tried to make us understand what is the meaning of the word act and then what are the different types of act, and therefore, he was very scientifically trying to explain everything. But when it comes to the concept of Grundnorm, it amounts to some vagueness, because he did not clarify that what would be, because otherwise he would say that Grundnorm is also pure, but then we might understand that Grundnorm cannot be pure, because ultimately you can't go beyond it. So, maybe that we will come to that example of our constitution. Suppose if we consider our constitution as the Grundnorm, can we say that constitution does not contain the political system or how the governance can be run and what is the socio-economic philosophy of our governance. So, all these things are there in the constitution, but saying that even the Grundnorm is also pure, that will be saying that the exact meaning of Grundnorm according to Hans Kelsen, that is not pure. So, it was vague, and further even the norms cannot not always be pure. Sometimes it contains the economic objective of the country, the sociological objective of the country. So, what he said about the jurisprudence in which the basis of jurisprudence will be the norm, the norm also cannot be pure. So, although he tries to make norms very pure, but then ultimately what we should know that norms cannot be always pure. Another weakness of Hans Kelsen's theory is that he overlooked natural law. Natural law we will discuss and understand in the next lecture, but here just I want to tell you that Professor Hans Kelsen, he did not give weightage to the natural law. And next great thing about Hans Kelsen was that he compared international law with primitive law, because he said that in international law sanction was missing. Now, but he was right. Before the Second World War, international law did not have sanction. After the Second World War, when the New World Order was created, when the United Nations was created, thereafter, gradually international law started to insert, started to incorporate the sanctions in it. So, at that time Professor Hans Kelsen was right when he said that international law was like primitive law because there was no sanction, but he said that in future it will have all the characteristics which the modern law have. So, he had predicted, and his prediction stands true, that he said that international law in future will have some kind of sanction. He says that no dualism between state and the laws. If you compare Professor John Austin had said that no, state is different and law making is different, but what he says that state and legal order both are the same, because everything derives its validity from the Grundnorm. So, Grundnorm is the norm from which even the state derives its validity, and therefore, the state and the laws both are not different things, but they are also the same thing. So, with this we have tried to understand the different aspects of Professor Hans Kelsen, and we also will try to understand that how his theory can be applicable in our country Bharat, whether Bharat also has the Grundnorm, the basic legal norm, whether we have also the different types of regulations, positive regulations, negative regulations, and the answer you will have to understand that answer lies in the fact that when you look at the constitution of our country, if you say that this is the Grundnorm of our country, then what you will do? You will say that can every law, every norm be tested on the basis of that great or the basic norm, which is Grundnorm? The answer is yes. We have earlier said that even the Supreme Court tests the validity of law. When someone will challenge the validity of law on the basis whether law is ultra vires the constitution, the court will try to test the validity. How? How will the Supreme Court test? Because only there are two courts which have the power to interpret the constitution. One is the high courts of the country and other is Supreme Court of the country. So, when the matter, suppose if a state made law, if a provincial legislature made law is being challenged in the high court, even high court will test the validity of the law with the Grundnorm, the constitution. And the Supreme Court, suppose if the central legislature has made a law, then central legislature made law, that will also have to be tested with the Grundnorm, that is the highest norm of the land, the basic law of the land. And once that test is being done, then what will happen? You remember the case of Menka Gandhi, that Menka Gandhi, when her passport was impounded, the action of the passport officials, that was claimed that it was properly legal according to the norms. But what happened? when Menka Gandhi went to the Supreme Court, Menka Gandhi contended in the Supreme Court that the norm which is there in the Passport Act, that is not according to the Grund norm. And thereafter what happened, that Supreme Court started to discuss that thing, the contention of Menka Gandhi, that whether the statutory law which is there in the Passport Act of 1967, whether that conforms to the Grund norm, which is the Constitution. Then in the Supreme Court, various different contentions were raised by the state of the country, our country, the legal councils of our country. They were saying that no, the action was properly legal, because the manner in which the passport was impounded, that was according to the section 10 of the Passport Act. Where is the illegality? And we will not go to the Constitution to test its legality, but we will just look at the norm which is there in the Passport Act. We cannot expect that the passport officials will go and see that whether it is constitutional or not. But then the contention of Menka Gandhi was that no, we have to test it on the basis of our highest norm, basic norm, Grund norm, and what he wanted to tell through his counsels, that the Grund norm is given in Article 21 of the Constitution, which is the right to life, and Article 19 of the Constitution, which is about liberty. She wanted to go abroad and her passport was impounded at that time, when she had to go to some other countries to deliver lectures in the international conferences. But at the moment just before she was about to leave, her passport was impounded. So how she would get even the visa? So what happened, that the Supreme Court in this case, that is an interesting case, if you have time you should read that case, Menka Gandhi case, in which Supreme Court finally found that the passport impounding was not according to the fundamental principle of liberty, fundamental right to liberty. Now this liberty is that a person can go abroad and passport cannot be impounded, at least when you do not give a hearing. Now this hearing was, how the court said that this hearing was essential. Now that court said the hearing was essential because it was according to the fairness, and that fairness is derived from Article 21, which says that the laws which would be established, procedure which will be established by law, that should not only be any procedure established by law, but that should be also procedure established according to the fair law. So that fairness has also come through it, and the Menka Gandhi case is a reminder that the court went to the Constitution to test the validity of the norm, and that norm was the norm of Passport Act. So students, you might have seen that in our country also this is the kind of testing of the validity of norm. You might also remember the case of Keshwanand Bharti. In the case of Keshwanand Bharti, when the matter went to the Supreme Court, that can the land or the estate of Keshwanand Bharti, who was a resident of state of Kerala, can the estate of Keshwanand Bharti be taken by the state? Because that was the time of taking the land, those persons who had lot of lands. The state had the power, the state was given the power to take the land from that person and to distribute it amongst the poor people of the state who were landless people. So by virtue of those powers those norms were created, and by virtue of those norms what happened, that the state of Kerala took away the estate of the Keshwanand Bharti, and what happened, that Keshwanand Bharti challenged it in the Supreme Court, and the contention of Keshwanand Bharti was that this law, which was the norm which was created by the state of Kerala, that norm was authorized, that norm was permitted, that norm was commanded, but when it came to the constitution, which was the highest norm, when it came to the Grund norm, you should also look at it, whether our constitution said that there will be amendment to this effect, because the union legislature had amended the laws by which the estate of such persons can be taken away, because before that the property, right to property was a fundamental right. So, that was the norm. Fundamental right means a great norm, superior norm, and that superior norm was there, which was there in the constitution. So, it meant that this was a kind of Grund norm, but then that was also amended, the constitution was amended. So, this is also a question. Suppose when the this theory about pure theory, which says that Grund norm cannot be questioned, Professor Kelsen said Grund norm, you should not go to the point to challenge the Grund norm itself. But in our country Bharat, what we see that the constitution can also be amended. Keshwaran Bharati is an example where the constitution was amended, and amended in the part which was a basic part, fundamental right part, and that was amended, and that was challenged in the Supreme Court itself. So, in our country what we have seen that Hans Kelsen's theory that Grund norm is very pure, Grund norm is fundamental, Grund norm cannot be challenged. Now, that is not the reality in our country. The constitution can be amended, and in Keshwaran Bharati, if you have time you can read this case. In Keshwaran Bharati, what happened that the court, Supreme Court in this case, laid down a new theory, that was the theory of basic structure, by which the court said that the parliament, union parliament, has the power to amend the constitution, but at the same time union government does not have the power to amend every part of the constitution. It cannot amend the basic structure of the constitution, and the basic structure was given the sacrosanct status by the court way back in 1973. So, this case is a reminder that the court on the one hand allowed the amendment in the constitution by the union legislature, but at the same time the court said that some portion of the constitution, those are sacrosanct in nature, they should not be touched by the legislature, they should not be touched or amended by any kind of government who is in power. So, at the one place the constitution was given highest status, some portion of the constitution were given highest status which cannot be touched by any part of the state, but other portions of the constitution, those were given not that status. It meant that the union legislature has got the power under article 368 of the constitution to amend most of the parts of our constitution and leaving the basic structure of the constitution. So, what is the basic structure? Who will decide the basic structure? Again, that is not clear, and that was how even Professor Hans Kelsen, when we said that the idea of Grund norm is vague, that was also the pattern in which the judgment by the Supreme Court was given. The Supreme Court did not define what was the meaning of basic structure. The Supreme Court did not say that basic structure contains this, and thereafter it did not give the exhaustive list of such kind of basic structure. In one case it said that free and fair elections, that is the basic norm, that is the basic structure, and in another case like Keshwaran Bharati case, what happened that the court says that you cannot amend any portion of the constitution. So, what we see that Professor Hans Kelsen's theory in Bharat, that is not fully true, fully adhered to, but yes, it is very important how we understand the different things, the different norms, the meaning of the norm, and then we will move on to the Grund norm, and we try to understand the Grund norm itself. So, in this lecture, I hope that you might have understood the different types of components of norm and how norms can be related to the Grund norm, how a norm is effective, how the norm is valid. So, I thank you all for your kind attention. I hope that you had a great day. Thank you.
Hi, my name is Gillette Sam and I teach sociology at IIT Kanpur. One of the things you must have noticed if you read or if you talk to people around you is that they often refer to something called globalization, or they often say we live in a global world. What does this mean? Today I'll tell you about how to think about globalization or interpret the word global in a sociological manner. When sociologists refer to globalization, they refer to three things. The first is that that it involves transplanetary processes, which means that something is going on across multiple borders, right? The second is that it involves heightened liquidity and interconnected flows. Now, by liquidity, and this is a term that was coined by the sociologist Zygmunt Bauman, we refer to the increasing interconnectedness of things across the globe, but we also refer to increasing instability across the world, which means that potentially something that is occurring many kilometers away from you actually influences the place that you live in. So, if there is a natural disaster happening in one part of the world, maybe that causes people to migrate from that area and they come and settle where you stay. So, that is what we mean by liquidity. And of course, when we are talking about liquidity, we are talking about things that are really moving from one place to the other. Now, the third aspect, and this is something that you may not conventionally come across in the way people use globalization, is that of structures. So, let's take an example. Supposing I, as an Indian citizen, wish to visit a foreign country. Let's say I want to go to South Africa. Can I just pick up my bags and hop on the next plane and go to South Africa? Any logical person is going to say, no, wait, you need to have documents such as your passport or visa. Now, this passport or this visa is a representation of the larger structure that governs how people move across borders. So, we have things like border control, national security agencies that consider what kind of people are going to move from one place to the other, correct? So, when we think about globalization, an average person typically tends to think about things moving or people moving from place to place. As sociologists, we also consider that there are structures that facilitate or direct this movement across multiple borders.